नमस्कार दोस्तों, मेरा नाम श्रीनिवास एडवोकेट है। मैं इससे भी पहले भी कई वीडियोस अपलोड करा क्रिमिनल प्रोसीजर कोड के बारे में, क्रिमिनल प्रोसीजर कोड। तो आज जो मेरा विषय है वो सेक्शन 377 से 395 ऑफ CRPC आगे अबाउट फाइलिंग अपील। तो एब्सेंट ऑफ अपील अपीलेंट अगर हुआ कभी अपील में तो क्या है पोजीशन बोल के है। अगर किसी कारणवश अपीलेंट या वकील साहब उनके कोर्ट में अपेयर नहीं हुए तो व्हाट इज़ दी अल्टीमेट, कोर्ट शुड डिस्पोज ऑफ अपील इन मेरिट्स। तो मेरिट जो है, केस का मेरिट है, उसके मद्देनज़र उसको जजमेंट दिया जाएगा या अपील अलाउ करना या डिसमिस करना होगा। तो ये जजमेंट आगे नरेश कुमार वर्सेस स्टेट ऑफ यूपी 1981 क्रिमिनल लॉ जर्नल 378 पेज नंबर है। तो सो व्हेन द एक्यूज इज नॉट अपियरिंग बिफोर द कोर्ट और the counsel due to some reason could not appear before the court, what is the ultimate remedy left to the appellant or the accused? The court should not have to pass any order because the counsel is not appear. Court has to go into the merits of the case or the document which are available before the court. The court has to pass order basing on the records present before the court. The court should not dispose of appeal on merit. Naresh Kumar versus State of UP. So, if the documents are with the court, no dismissal for default. Even if you will see through civil procedure, when the petitioner or the appellant or the counsel is not present in the court, due to any reason, the court will dismiss the appeal for default. But in criminal procedure, there is no such procedure which says the petitioner or the appellant or the counsel is not present in the court, the appeal has to be dismissed for default. There is a judgment to that effect. If this says there is no dismissal for default, examine the record and would decide the appeal on merits. Nathuram versus State of UP 1990 Criminal Law Journal 452. Now the question is whether government want to file appeal against the acquittal. What they are supposed to do? It's a mandatory aspect which has to be considered. In 1975 Criminal Law Journal 141, leave mandatory. Government must obtain leave to appeal before preferring appeal against acquittal. This is the judgment. What is the next option? If the High Court, where we will file appeal against the conviction or appeal before the High Court, what High Court has to do? Remand by High Court. High Court has to remand the appeal to the trial court. It is the judgment. It says, High Court in appeal cannot remand the case to enable the trial court to write a fresh judgment. It says that a fresh judgment could not be again given in that particular subject. High Court in appeal cannot remand the case to enable the trial court to write a fresh judgment, considering some points omitted by the trial court. Proper course is to decide the case itself or send the case for retrial. So, when appeal is brought before the High Court, it has to do is decide the case itself. High Court has to decide the case itself or send the case for retrial. Not, it has to send for retrial, not for fresh judgment writing. It is a judgment of which is published Mahinder Singh versus State of Punjab, AR 1985, Supreme Court 383. When a matter is filed before Supreme Court, what is the thing that has to be done by the Supreme Court? Remand by Supreme Court. When the finding of High Court are contradictory, Supreme Court should remand the case to High Court. Harbhajan Singh versus State of Punjab, AR 1987, Supreme Court 1625. And what is the guidelines which was being issued against the filing of appeal against acquittal? There is a guideline prescribed. It is a case State of Assam versus Manohar Ali, 1987 1, crime 748, Guwahati. The guidelines are, even when the High Court does not agree with the view of the trial court, yet reaches the conclusion that the view expressed by the trial court is reasonably possible, the finding of acquittal should not be disturbed. And B says the appellant court should be slow in disturbing the finding of fact reached by the trial court, who had the advantage of observing the remote action and conduct of the witnesses. Ordinarily, an order of acquittal should not be set aside unless there is manifest illegality resulting in failure of justice or to prevent grave miscarriage of justice. This judgment state of Assam versus Manohar Ali. And with regard to two views possible, when a appeal is against acquittal, there are two views which were supposed to be in the appeal. If an appeal against acquittal, both the views, namely one leading to conviction and the other to acquittal, are reasonably possible, the verdict of acquittal is not to be disturbed. This is judgment is Dinant versus State of Bihar, AR 1980, Supreme Court, 1199, page number. And another point is where reasons given for conviction of accused were fairly sound, but at the same time, the reasons given by High Court for acquittal cannot be characterized as perverse or wholly unsound. The Supreme Court will not disturb acquittal under Article 136 of Constitution. State of UP versus Lala Singh, 1990, two crimes, 290 SC. These are the some of judgments which speak about what is the steps those has to be taken, or what order has to be passed by the Supreme Court or High Court when the matter has been brought into their knowledge or appeal has been preferred before them. The Supreme Court or High Court, these judgments which I have just now told you about are the guidelines or the things which are supposed to be taken into account. Sometimes it so happens that one of the accused don't want to file appeal and one prefers appeal. What is the alternate order that will be passed in such a appeals? One co-accused appealing against the conviction, other not affect. Co-accused not appealed, conviction of another accused set aside on appeal. Finding interdependent and inextricable integrated. The non-appealing co-accused is also entitled to acquittal. This is Harinath versus State of UP, AR 1988, Supreme Court, 345, page number. So these are some of the judgments. And one of the point in considering an appeal against conviction, the High Court will not be right in dismissing the appeal preferred by the convicted person summarily, where the appeal raises some arguable point which requires consideration. The content of the power of High Court in considering both the types of appeals in same, but the difference lies only in the approach. State of Kerala versus Venkita Rao, 1970, Madras Law Journal, Crimes, 233. This is about acquittal and conviction, appeal against acquittal and conviction, distinction which is here. I just want to go to read this once again. Appeal against acquittal and conviction, distinction, they have shown, they have mentioned with regard to the distinction. In considering an appeal against the acquittal, the High Court has to keep in mind 1. The view of the trial judge to be credibility of the witnesses. 2. The presumption of innocence in favor of the accused. 3. The right of accused to be benefited of any doubt. 4. The slowness of an appeal. Appellant court in disturbing a finding of fact arrived at by a judge who had the advantage of seeing the witnesses. These principles must be borne in mind in considering an appeal against acquittal, not only when it is finally heard, but also under Section 384 of the Code in considering whether the appeal should be dismissed in limine or whether notice to the accused should be issued. On the other hand, in the considering an appeal against conviction, the High Court will not be in right in dismissing the appeal preferred by the convicted person summarily when the appeal raises some arguable point which requires consideration. This is with regard to distinction within which is being given, and these are the points which are very much important while filing appeals, or what is the outcome you will get by filing appeal against acquittal or conviction. Thank you for very much, friends. This is something with regard to section 372 to 395 about filing appeals in acquittal case or conviction case. My name is Srinivas Advocate. Please share this video or like this video or subscribe my video. Thank you very much.